Okay, a special thanks to Julie and everyone that has contributed to putting this year's CNTA conference together. It's a wonderful technological feat. It's a wonderful opportunity also to reconnect with friends and colleagues while meeting new faces, albeit over the internet. In this panel, we are changing gears a little bit to explore the applicability of compensation in more densely settled regions of Australia. Indeed, this emerging jurisprudence has gained significant momentum since the High Court's Timber Creek decision. Although to date little attention has been given on how compensation claims may be developed in more urban areas where settlement occurred much earlier than 1975. Growing reconciliation and truth-telling initiatives across the country are gaining widespread attention, and within Victoria, these initiatives surround a broader political agenda to establish the first Aboriginal treaty in Australia. Subsequently, there is a clear need to focus attention on what opportunities and challenges may exist for compensation, and indeed what methodologies for research may be developed for compensation claims in these more densely settled regions of the country. Late last year, I caught up with one of Australia's leading compensation barristers, Stuart Glacken, anthropologist Wendy Ash, who has produced research for the Timber Creek claim, and Michael O'Kane, who is the research manager at First Nations Legal and Research Services in Victoria. We began to flesh out some of these questions in a podcast that is available on the CNTA website. For those of you who could get around to watching this podcast in preparation for today's session, you're absolutely wonderful, thank you. For those of you that couldn't get around to watching that, that's totally fine, and don't fret, because today each of the panelists will be providing a brief overview of their presentations before we dive into some complex and to adopt the CNTA's wording potentially dangerous questions. Unfortunately, Mick can't be with us today, but we have John Morton joining us to summarise some of the key points that Mick raised, while also sharing some of his own thoughts on this matter. To finish up, our wonderful chat monitor, John Sutherland, will select a few questions to present to the panel from the audience, so please do send your thoughts and questions throughout the session, as noted previously, using the Q&A function, not the chat function. Over to you, Stuart, now.
Good afternoon to everybody. I've been asked to make some introductory remarks on the High Court's judgment in Northern Territory v Griffiths, known as the Timber Creek case, in which the court addressed for the first time the assessment of compensation for the extinguishment of native title. In doing so, I'll attempt to remind people of the key issues in the case and how they might engage with applied anthropology in a high-level sense. Now, in broad terms, the court addressed two issues. The first was how any economic component of loss on the extinguishment of native title might be ascertained. The second issue, which is the one of primary concern for anthropology, was how diminution in the connection between people and country caused by dispossession might be reflected in an award of monetary compensation. Now, like any case, the issues were shaped by the facts. The key facts included that the town of Timber Creek was proclaimed as a town in May 1975, and then developed by the subdivision of land, the grant of development tenures and so forth. This occurred largely after the commencement of the Racial Discrimination Act on 1 October 1975, and in the period up to 1 January 1994, when the Native Title Act commenced. Now, hopefully you'll have on your screen a map which illustrates the development of the town, and it's reproduced in the High Court's reasons for judgment. I hope someone can confirm with me that you've got this image. And I've got a message saying the map is coming shortly. Here it is. Now, the development of the town and the facts of the case are illustrated perhaps by focusing on the red blocks on the map, which were the parcels in issue where extinguishment occurred. Now, this map depicts a view of country from the perspective of European cartography, with a very artificial overlay of some lines of the travels of spiritual ancestors of the peoples concerned, being those squiggly lines in different colours. Now, one of the challenges in a case of this kind is how a Western legal system can ever attempt to understand the very different perspective of Aboriginal people have of their country, where connections are not measured by these convenient metes and bounds used in Western surveys of land. The work of applied anthropology provides the necessary bridge by which lawyers engaged in a claim, and most importantly, the court that must decide the claim, can possibly reach a better understanding of these nuances. Now, I won't dwell on the first issue of economic loss other than to remark that the court recognised that native title, like other land titles, does have an objective economic worth by market value, even though native title cannot be traded like a fee simple title can. That also resonates with Aboriginal traditions of exchange for use of country that is otherwise inalienable beyond the community concerned. On the second issue, involving non-economic loss or cultural damage for dispossession, in this case, the dispossession was partial and incremental. It concerned the developed part of the town, that is the red parts on the map, which are only a small part of the wider country of the peoples concerned, and this dispossession occurred over the years on a parcel by parcel basis. Now, the spiritual connection to the affected parts remained and was strong, but loss of physical access, including loss of the ability to rehearse country in ceremony in situ and to be able to look after that country, impacted upon that connection, manifested by notions of loss of social standing, sorrow and shame for these Western intrusions. The High Court identified these impacts as a subjective or non-economic component of loss, termed as cultural loss or damage. I think there are at least 3 points of importance for applied anthropology arising out of the judgment, if I might identify some key paragraphs and commend their reading to the audience. The first is that damage was compensable by reference to the customs of the peoples concerned on speaking for country, even though an enforceable native title right to control access had been earlier extinguished by the non-compensable historic grant of pastoral leases, reference paragraphs 158, 187. The second point is that general evidence about connection not linked to particular acts or sites, in other words, these red parcels, did not detract from expressing the effects of the acts on a group's connection, so it was equally relevant or legitimate to refer to connection and expression of loss of connection in relation to other parcels, see paragraphs 187, 188. And thirdly, impairment was not to be understood by reference to what occurs at a particular lot or lots. There is a more general feeling of loss of connection with country, which can be incremental, see paragraph 204. On the key challenge of intersecting Western and Aboriginal conceptions of landed interest, the joint reasons employ the metaphor of a damaged landscape painting, a painting that depicts, quote, a single and coherent pattern of belief in relation to a far wider area of land, end of quote. The Honour said it was as if holes, like the red parcels on the map, were being punched into a painting that had previously been one coherent and integrated landscape, and compensation was not measured by the holes viewed in isolation, but by effect of the holes in that wider context, see reasons 205 and 219. Now, if we can call up a second image, I like to think that this metaphor may have been inspired by a painting of the town that will hopefully come up on the screen. Maybe there's a technical problem, but there should be a painting. And if it need not matter how it be moved, which is one of the ironies of this painting, because of the different perspective it has. There's no, if I can put it this way, there's no left or right or upside down. Now, this painting was done by a lead claimant and it was put in evidence in trial as an exhibit. The painter passed away before the High Court hearing. The point I want to make is that the painting shows this town, and it's a painting of the town of Timber Creek, with a much different outlook of country that someone like myself, raised in Western traditions, struggles to comprehend. When we contrast this picture of country with the earlier European map, the challenge that the Western legal system faces in attempting to translate or travel between these two worlds is obvious. It may be daunting, but I think the judgments in the Timber Creek case, from the trial judge to the High Court, at least show that we lawyers are alive to the challenge, if not equipped for it. And as I said, applied anthropology provides the gateway for improving our understanding about that intersection of two worlds. They're the contextual remarks I wanted to make to open this session.
Now we'll be hearing from Wendy.
Hello. Yes, hello from beautiful Larrakia country. In this summary, I will focus on three aspects of the video recording, which I elucidate a bit further. The particular circumstances of the Timber Creek compensation claim was that Kingsley Palmer and I had already done research and given evidence for the successful Timber Creek native title claim. As Sturt noted, the assessment of cultural loss needs detailed background evidence. Fortunately for the compensation claim, we could draw on that previous research. Timber Creek is a small town and quite remote, so that European impact has been less than in other places. For example, language and ritual is still evident. Of course, changes are occurring there too, and sadly, the two senior claimants have since died. So there's likely some of the depth of cultural knowledge is lost. I've described some aspects of compensation research in the video, but note that this is not a template to be followed, but only the start of an exploration of ways to approach the subject. I acknowledge the Southern context is very different, but believe there remain common avenues of approach to compensation throughout Australia. In the Timber Creek report, we elucidated Naliwara words for concepts such as broken, spoilt, and gut-wrenching. Gareth Lewis's excellent presentation on measuring damage and loss in respect to sacred sites considered the question, have anthropologists developed the language to talk about trauma and loss? He argued, and I agree, that we have not, and we need to do so, otherwise we run the risk of diminishing the extent and complexity of trauma and loss. Gareth described how Aboriginal people often present ambiguous and understated accounts of loss, which mask a whole pain of world damage that can extend for generations. One way of approaching the subject is to give specific examples of loss that have impact for both individuals and the group as a whole. In Timber Creek, Sturt has explained how the judge used the metaphors of holes in a painting to explain that loss of parcels of land or site damage destroys the whole. Gareth gave a comparable example relating to site damage in Bootu Creek, where the effect was described as ripping out a page in a narrative book. There should be a painting shown here, but in the video I mentioned, this painting was done by the senior claimant in Timber Creek, Alan Griffiths, showing ceremony for country. It is another way of illustrating the intimate interconnectedness of land and people. In the video, I mentioned an example of significant site damage of dingo dreaming, where the owner of a caravan park in Timber Creek poured concrete over a causeway, damaging it extensively. Soon afterwards, this man was killed in a single vehicle accident on the highway. Claimants directly attributed the death as retribution of the dreaming. Gareth gave a similar account of an NLC officer in Tennant Creek who is seen by some traditional owners as having facilitated site damage by a mining company. The officer died of cancer soon afterwards, and this was also seen as retribution from the dreaming. There is also a very personal sense of responsibility that senior claimants feel. Jerry Jones described his feelings of shame and grief about damage to a stone pillar that represented the headdress of the humpback dreaming. The damage was done by a road crew, and Jerry was not even present, but still felt that the community would blame him for not protecting it. On reflection, one of the things that underlines the importance of this catastrophe in Jerry's mind was that over many years of talking to him, he mentioned it to me regularly. In the Timber Creek report, we described the concept of Aboriginal equilibrium needing to be maintained. With loss or damage, compensation must follow. The point is that damage and loss is part of a complex interrelationship between individuals, community, and their spiritual landscape. And the anthropologist's challenge is to describe this clearly and comprehensively. I now hand over to John Morton to give a Southern perspective on compensation.
Hi, hi from Gubbi Gubbi country, where the situation is very, very different. I'm well in southeast Queensland these days on the coast, and I live in an area where I guess you would have to say that Aboriginal people have been impacted massively, and more, or at least more extensively than in somewhere like Timber Creek. Now, I've just been roped in for Mick, and so those small comments about where I am and the kind of situation that Aboriginal people have experienced in this part of the world is to draw attention that Mick is, he works with the First Nation Legal and Research Services, and that is part of, I gather, the Victorian Traditional Owner Corporation Group. So this is tied up, I believe, with the process of treaty making. The Victorian government aims, I believe, to negotiate the first treaty in Australia, and that part of that is also the URUC, which is a sort of truth commission. Now I am not entirely au fait with all those. I haven't lived in Victoria for about 11 years, but I'll try to give a summation of the major points that Mick gave in the meeting that you were asked to listen to. And then we'll move on from there. But that just gives that does give the context where he's speaking from, and that might explain some of the ways in which he's approaching things. So, first off, he was asked about what kind of contribution Aboriginal people, anthropologists might have in making a contribution to issues of compensation and redress in that context, in that broader context, which of course goes beyond and outside of the native title domain. So he didn't necessarily only have a focus of attention on that window between 1975 and after. He was also thinking about something longer term, and for that reason, when he was asked about what anthropologists should be doing, he went straight to the idea of ethnohistory. So he made a plea, I guess, to say that, well, this is what we can contribute, and this is what we should be contributing. That we would do an extensive regional ethnohistory. I mean, and what struck me about that, of course, is that a lot of that history has been written and written about quite extensively, but largely by historians. So he does mention and seem to have chiefly in mind things like massacres, things like the Stolen Generation, things like the 1869 Aboriginal Act, which put everybody under the control of the state. There's a number of things like that that have been very, very well documented, but what possibly hasn't been quite so well documented, in my experience, thinking about Victoria, given that I have been involved in a couple of claims down there on one occasion very, very intensively for a number of years, is that a lot of that history requires some sort of anthro-analytical input. So, and in many ways, we are not in a bad position down there. I say we, people are not in a bad position down there who are involved in the research down there, because they're fortunate enough to have all the research that was done by people like Diane Barwick, an anthropologist from about 1960, which extensively documented Aboriginal history, and largely from, if not, I would not say exclusively, with a kind of anthropological perspective. Her material needs some careful handling. It is what, 60 years old, some of it. So you would bear that in mind. It's the context in which it was produced. But I just want to underline that there is a lot of anthropological analysis that needs to be done in terms of the transformations that have occurred in the Southeast. And I've written about this in relation to the Southeast in the paper Mother's Blood, Father's Land that I published some years ago. So there's a lot of anthropological analysis about family life, about estates, about the likely way in which estates came together, about movements, about how the act and the forced movement of people around the state helped to give rise to certain sorts of Indigenous responses within the terms of traditional association and connection with country. So that was the first point about ethno-history and a very long-term ethno-history. The second point that I draw attention to, and I have to thank Wendy for partly doing this summation before I did. I think she's got the same details in her notes as I have here. The other thing he talks about is loss of access to country, both before and after 1975. Now, that obviously depends on what we're talking about in terms of nature of connection. When you're looking at the ethno-historical material in a place like Victoria, and you're looking at it, say, relative to the education that you've had in anthropology and the case material in situations like Timber Creek, you're thinking about a kind of transformation of a very, very long-term situation where lack of access is not recent. Lack of access and mass movement around the country happened on a devastating scale. If I remember right, the Aboriginal population of Victoria fell to 10% of its pre-contact level. And I remember in the Gunai Kurnai claim, that kind of statistic had to be dealt with as part of your argument about what connection to country could be, given that kind of massive impact on a system, and the way, and you have to at least hypothesize what you think is the most plausible way of Aboriginal people responding to such devastation. in terms of succession and so on. So Mick speaks in terms of the more contemporary situation. Mick talks about the way in which Aboriginal people continue to navigate country, particularly spiritually, but also materially in terms of resources and using local resources. It is possible, he believes, but the research would need to be done to make it convincing. It is possible, he reckons, that the kind of navigation that contemporary Aboriginal people in Victoria undertake on country would possibly count as evidence in a compensation claim that is based on the shall we say, native title business after 1975. He also, this is the third point, he draws attention to everywhen, Stanner's concept of everywhen. If anybody knows that concept, it seems to be reiterated anytime anybody talks about the dreaming, because it's such a memorable phrase. So the idea is that everywhen is past, present, and future, and that time, as it were, doesn't matter in the sense of we think about time in terms of past, present, future. But he seems to be thinking about this in terms of transgenerational trauma, that if you have your rights and interest interrupted in some way at some stage, and that causes some kind of damage to you personally or to country, then you can expect that to be something that is continuing, sort of like, you might say that the dreaming is continuing. He may have had something quite specific in mind to adopt that metaphor for intergenerational trauma, but I'm not sure I could read his mind on that. But apropos of that, I would just draw attention to that map that I produced yesterday. I won't put it up again, but it was the David Moaljali map. And part of what I said about that was he was asked about that concept of Australia as a field of interaction between all the places and the stories. And I would just want to read that relevant section where he's talking about the southeast and similar places. So Jutta Malnich, who is the co-author of this book, asks him a question. Says, I find this concept of a corpus australis extraordinary and wonder if other continental bodies are also lying on their backs, floating in the oceans that surround them. He answers, we think along those lines, but we know only Bandai, that's corpus australis. On this, we interact as a corporation. It is intact. Intact? What about the areas where there are no Aboriginal people still surviving, or at least not living traditionally there any longer? Oh, you're wrong there, thinking like that. The land remains. You can't get away from that. It acts for the people and their imprint is still there. If the land sinks into the ocean, the symbols will still be there. Only if the whole continent is blown to pieces and nothing is left of it, then it will be finished. Which is an interesting quote to think of in terms in relation to sacred site damage. So I'm thinking that, in my experience, and obviously in Mick's, the southeast, Victoria in particular, is a place where people, in Stanner's terms, and I'm quoting Stanner here too, look for signs of intent in the land. They are looking for communication with the ancestors that are in the land. So that is relevant, I believe, in terms of the kind of two-way communication and identification with country. Am I going over time?
Yes, just a little tad there, John, but what you're saying is so great. I could give you another 2 minutes or so if you want.
Oh, there's only one more point.
Okay.
There's only one more point, and Mick was particularly concerned, it seemed, about the ethics of all this and about the effects of all this on people. I mean, I've worked a little bit with Mick in the past, and I know he possibly demonstrates more angst than most of us in relation to these issues. So I think he's particularly sensitive to them. I'm not saying that the rest of us aren't, of course, but he's concerned about how, in the Victorian context, particularly in relation to Europe, the Truth and Justice Commission, how to get that testimony in an ethical manner. I think he thinks there may be problems about how much of it would get in the would have to get in the public domain, how much of it would increase trauma rather than sort of release people from trauma in telling their stories. He uses the term not weaponizing. It's about how do we do this without weaponizing what people are telling us and their story. My only comment along those lines, I think, would be, well, it's a bit like the situation that everybody is in when they do field work and they have to sign some sort of ethics declaration or agreement before they undertake the field work. The problems are difficult. They're always negotiated on a one-to-one basis at any particular moment. But it's certainly not the case that, I mean, sometimes we will find ourselves as anthropologists in difficult situations, not least of all because we don't always agree with claimants or others about how we do that. So I will leave it there and we can move on to where we're going next.
Question time. So thank you, panel, for your wonderful reflections and for really setting the scene for the questions this afternoon. Before we go to the audience, I just wanted to jump in with one question, or so two. So across Australia, there are a number of adaptations occurring within Aboriginal societies, which are prompting new ways for anthropologists to understand and describe these societies and the nature of the adaptations in and of themselves. Societal models and the use of Peter Sutton's families of polity are just some frameworks that are being used. Herein lies two questions. How might these adaptations challenge current legal understandings of traditional Aboriginal law and custom? And how might this be detrimental to future compensation and current native title claims? So I'm really asking here about the longevity of these models.
I'm happy to start up to give my answer to that question. I think clearly Aboriginal people have always changed and adapted to different circumstances, but I think we make a wrong assumption that change is always one way. So the assumption is that it's going from a state group model to the families of polity. I think Susan Donaldson's presentation yesterday demonstrated that that the current claimants are often asking, what did the old people say? And they give tremendous value to early ethnographic accounts. So she suggests that in some cases, and I'm aware of this from my own experience as well, people are actually reinvigorating a more so-called traditional system. So I think obviously anthro reports have to reflect what is actually on the ground and what is happening not just to try to fit a preconceived model. However, on a positive note, and I'm thinking of Sturt here, we have to remember the legal system has responded to Aboriginal and anthropological evidence very well. For example, not always, but in many cases, under the ALRA claims, there was the first 10 years basically followed a patrilineal model of local descent groups, but gradually there was a more inclusive model which incorporated the matrilineal model, and then later on there was an acceptance of the language group model. So I think even more recently, David Tricker presented the case in a native title claim where there was a succession, not just a state group to a state group, but language group to language group, and that was accepted by the federal court. So I think that if the anthropological evidence is coherently and logically presented, even if complex, one would hope a reasonable judge or government negotiator would respond positively. So I hand it on to perhaps John or Sturt from there.
Well, I might just say something about the families of polity model that Courtney drew attention to, because I worked with that model very, very extensively in Victoria, and had to do, I might add for the first time in my career, really, the sort of fine grain analysis of that. And it was a very interesting exercise in terms of understanding what was going on with people relative to what the historians had said about that and had dug up in their research, including the in-house historians with NTSV, as the organisation was in those days, but also with Aboriginal people's perception of themselves as belonging to a tribe, and how they had over the years incorporated. So there's a lot of work to do there in terms of really understanding the dynamics of families of polity in Victoria, and I think it's also true elsewhere in New South Wales, southeast Queensland, as I've discovered since, at least in southeast Queensland. Do you know those families of polities are not simple descent groups, and they don't go on forever, but actually charting how they reproduce themselves over time is extraordinarily difficult unless you are able to do the kind of long-term fieldwork that we never get a chance to do in native title research and similar applied arenas. So that's always going to be a problem, I think. And one of the outcomes of that problem in the southeast, of course, is of the I'm from everywhere man type approach that some people will undertake, because they have an ancestor from here, there, and everywhere. And I think probably everybody in Victoria knows a few well-worn cases of, multiple claims that I think are not probably anthropologically justifiable. That's all I would say at this point. There needs constant work, that issue.
We're just trying to get Sturt's camera on, but I'm just wondering, Sturt, if you wanted to add a few comments vocally.
Sure. When we're faced with situations where there may be multiple pathways to gaining rights to country, and people may have rights to multiple countries, or there's a spread than what may have been more traditional systems across Northern Australia, and indeed even in Timber Creek. It's probably illustrated by the circumstance that you have several estate groups, but the town itself is the estate of one group, but the other surrounding groups have other native title rights. There is a tension in the Act in that the key compensation provision is section 51, and that is there must be compensation for the effects of acts on native title rights. So that would technically bring in anyone who has rights to use land under tradition that may be affected by an action. Then on the other hand, there's a section 94, which fortunately I think most anthropologists won't be immediately concerned with, but it will burden them possibly later on. And that is when the court makes a compensation order, it has to do three things: name the person or persons entitled to the compensation, or the method for determining the person or persons. In other words, if you can't name them, is there some other criteria to find out who they are? Secondly, the method for determining the amount or kind of compensation to be given to each person. And then thirdly, the method for determining any dispute regarding the entitlement of a person to an amount of the compensation. So theoretically, one could have a situation where there is a wider grouping of persons with native title rights who are affected, but under applicable tradition, it's a narrower class of people who might decide how the compensation should be dealt with as amongst the community, what might be called intramural allocation. Now, it's a similar problem to dealing with just a determination of native title rights. And what we lawyers do in the court is that we tend to kick the can down the road and say, well, that's what a prescribed body corporate does. The native title holders will have a corporation recognised by the Act, and the orders in Timber Creek were for payment of the compensation to prescribed body corporate, and it will decide what to do with the money, whether to invest it or if to distribute some, who to distribute it to, and that burden will then fall upon anthropologists and field officers in the field working for representative bodies in sorting out those problems. So that's a legal perspective, I think, on the issues that you've just raised about different groupings of people having traditional rights to country.
It's John Sutherland here. There don't seem to be any chats or questions from the audience, so I guess I'll raise one, but others are welcome to put them in. Late last year, all the governments agreed a thing on guiding principles for native title compensation agreement making. I've just put the link up in the chat, and so I'd be interested to hear from any of the panelists on a role they see for anthropologists or lawyers in negotiating rather than litigating. Particularly, this agreement that has ideas of agreements should represent a full fair settlement and should be negotiated and agreed with free prior informed consent of native title parties. Would you see any use from that? I don't know, Wendy or John, in the work that you do?
Look, I haven't had the chance to look at that thoroughly. Certainly the idea sounds good that they're approaching it, but I'm a little bit nervous because if you all remember the bundle of rights issue in native title, where they tried to define specifically the way native title would be represented. So I apologise, I haven't looked at the detail. I think the idea sounds reasonable, But again, I also just defer to Sturt as well as whether he thinks that would be a reasonable way to go.
I think I can say that I might put things in perspective. When we think of Timber Creek being the lead case and so far the only case, and we think of it about concerning a fairly remote place in the Northern Territory and concerning what lawyers call in the Native Title Act past acts between 1975 and 1994 that were validated by the Native Title Act as part of that political compromise by the Keating government subsequent to Mabo. There's no doubt that the broad principles that the court establishes will have a much more general application. Now, at least in Victoria at two levels, there's a number of consent determinations of native title made in the earlier days, and John mentioned one of them, where under what's known as the Future Act regime, where essentially governments or proponents need to negotiate an agreement with persons under a consent determination for what's called future acts, then the guiding principles in Timber Creek will be relevant to what parties will negotiate. In other words, they'll come to the table thinking, well, these are the parameters in which we're acting. The second way in which it's particularly relevant in Victoria is under the Traditional Owner and Settlement Act, where there are two settlement agreements in force. There is a review system by the state government and traditional owners. As part of the original contract, it has to be reviewed from time to time, and the compensation measures in those early agreements are being revisited with Timber Creek principles and with what would be an uplift. And again, outside of those measures in those agreements, where people need to negotiate activities under the Victorian regime, the Timber Creek principles, I believe, will still be relevant in the same way when people negotiate future acts.
I'll just make one very brief comment, since I know somebody's waiting to get in for a question. Look, whenever I hear anything about the possibility of negotiated agreements, I go, yes, please. As opposed to the kind of work that anthropologists get called in to do when we're thinking about litigation. So I have a knee-jerk reaction to that, which is to say, on the basis of my native title experience, is that when you've got agreement making guidelines, you are always in a better position to get some kind of positive outcome. But of course, what that always does in negotiation is it basically gives state governments effectively they become the court, and that gives them, and that's emblematic of the amount of power that they have when they know that something is not going to be testable in court. So that's not always a good thing. So yeah, that's my only comment. I'm like Wendy, I'm pretty unfamiliar with this these guidelines that John you spoke of.
Look, I'll just jump in to say thank you. And we did have one question from David Trigger, although we have run out of time, unfortunately. But look, I just really wanted to thank the panel for your wonderful contributions today. Clearly, these issues are really complex, and there aren't necessarily any easy answers. And as Mick pointed to in our podcast last year, we are in a position of speculation in Victoria, so these things remain to be seen. But also, as mentioned, this panel does have a podcast which is available on the CNTA website, so please do make a virtual journey over there to access this recording under the compensation tab. Thank you all for today.